Hey guys, this is Vijay Dinakar. Today I want to talk about how domestic violence is defined for a domestic violence restraining order, or DVRO, in California. I've previously made videos about the benefits of filing a domestic violence restraining order, as well as a video about how to defend against a domestic violence restraining order. But today I want to talk about specifically what acts constitute domestic violence under the Family Code in California. And that is defined by California Family Code Section 6203, which defines what constitutes domestic violence or abuse. And I want to just actually read with you what that actually is. So California Family Code Section 6203 defines domestic violence or abuse. And it says, for purposes of this act, abuse means any of the following. 1, to intentionally or recklessly cause or attempt to cause bodily injury. And that's pretty straightforward. So that means anything physical, pushing, slapping, punching, grabbing, or attempting to cause bodily injury related to that. Number 2, sexual assault. Again, pretty straightforward. Number 3, to place a person in reasonable apprehension of imminent serious bodily injury to that person or another. So that means that if you're involved in some sort of confrontation and you basically attempt to hit somebody and thereby place them in imminent, meaning it's about to happen, apprehension of actually being injured, even if you don't injure that person, that is also abuse. Number 4, to engage in any behavior that has been or could be enjoined or prohibited pursuant to Section 6320. And I'm about to go into what that actually constitutes in terms of what's in Family Code Section 6320. And finally, abuse is not limited to the actual infliction of physical injury or assault. So clearly, the code contemplates that we're not just talking about physical domestic violence. And that's where Family Code Section 6203 and the whole entire Domestic Violence Restraining Order Act is not just what we consider sort of criminal domestic violence, but it's more than that. So as you can see, California Family Code Section 6203, Section 4, prohibits any behavior that can be enjoined or prohibited by California Family Code Section 6230. So I want to go through now the specifics of that code section, which is very new and which is very complicated, but which is very important. California Family Code Section 6230 says that the court may issue an ex parte order enjoining a party from molesting, attacking, striking, stalking, threatening, sexually assaulting, battering, credibly impersonating as described in Section 528.5 of the Penal Code, falsely impersonating as described in Section 529 of the Penal Code, harassing, telephoning, including but not limited to, making annoying telephone calls as described in Section 653 of the Penal Code, destroying personal property, contacting either directly or indirectly by mail or otherwise, coming within a specified distance of, or disturbing the peace of the other party, and in the discretion of the court on showing of good cause of other named family or household members. The first part of the section talks about what we clearly understand to be domestic violence. So anything physical, threats of physical violence, annoying phone calls, stalking, but then it also talks about prohibiting disturbing someone's peace. And later in the statute, it specifically defines what that means. And let's go through that now. So Section C of California Family Code Section 6230 defines disturbing the peace. Quote, as used in the subsection, quote, disturbing the peace of the other party refers to conduct that, based on the totality of the circumstances, destroys the mental or emotional calm of the other party. So destroys the mental or emotional calm of the other party is specifically what disturbing the peace means. Now, you might ask, what does that actually mean in practice? Well, there's lots of case law that defines what does constitute disturbing someone's peace, but it really means what it says, which is that if conduct would destroy the mental or emotional calm of someone in the same or similar circumstances, that can constitute the basis for a domestic violence restraining order. So what does destroying the mental or emotional calm of the other party mean? Well, it's an objective standard, and there are some appellate cases which define what are instances of disturbing someone's peace, but just objectively, the court is going to look at whether this act that you're saying is an act of disturbing someone's peace would actually and did actually destroy that person's mental or emotional calm. So clearly some examples are extreme verbal abuse, or even seeing, for instance, your child being abused by the abuser. That itself, the scene of that has been found to disturb someone's peace by destroying someone's mental or emotional calm. The statute talks about, quote, this conduct may be committed directly or indirectly, including through the use of a third party, and by any method or through any means, including but not limited to telephone, online accounts, text messages, internet-connected devices, or other electronic technologies. This conduct, again, this conduct referring to conduct that would disturb someone's peace by destroying their mental or emotional calm, includes but is not limited to coercive control, which is a pattern of behavior that in purpose or effect unreasonably interferes with a person's free will and personal liberty. So this notion of, quote, coercive control is a very new part of what constitutes abuse under the domestic violence restraining order system in California. And it literally went into the statute books less than 2 years ago. But the language that you see with respect to coercive control is on its face very vague. And that means that, at least in theory, it should be easier than it previously was to get a restraining order. And the statute does further define what is meant by coercive control. Now, since the statute is so new, there has not been a lot of appellate cases defining what coercive control means. So at this point, we just have to actually look at the statute. So examples of coercive control include, but are not limited to, unreasonably engaging in any of the following. 1, isolating the party from friends, relatives, or other sources of support, depriving the other party of basic necessities, controlling, regulating, or monitoring the other party's movements, communications, daily behavior, finances, economic resources, or access to services. So let's just actually backtrack a little bit and go through the first one, isolating the other party from friends, families, or other sources of support. So in theory, if you isolate someone, you could be the subject of a restraining order based on doing that. If you deprive one of the party of basic necessities, meaning you exert financial control over that person, again, someone could get a restraining order against you. Or if you control or regulate or monitor their daily activities, communications, finances, etc. Again, a very vaguely defined statute, but it on its own can give you a restraining order. Going on to number 4, compelling the other party by force, threat of force, or intimidation, including threats based on actual or suspected immigration status, to engage in conduct from which the party has the right to abstain, or to abstain from conduct in which the other party has the right to engage. So Section 4 talks about intimidating someone from doing something they have a right to do, or intimidating them out of doing something that they have the right to do, including and specifically mentioned is immigration. So I've seen this myself personally in cases where threats of immigration consequences made by one spouse or boyfriend, girlfriend to the other spouse are made. So for instance, if let's say you're an H-1 visa holder and your spouse is an H-4 dependent visa holder, you might say to that spouse, if you don't do this, I'm going to kick you out of the country. Or if you don't do that, I'm not going to sponsor you for a green card. So if you were to say that, based on this statute, you can actually, just alone on that, get a restraining order. Number 5, engaging in reproductive coercion, which consists of control over the reproductive autonomy of another through force, threat of force, or intimidation, and may include, but is not limited to, unreasonably pressuring other party to become pregnant, deliberately interfering with contraception use or access to reproductive health information, or using coercive tactics to control or attempt to control pregnancy's outcomes. So, engaging in reproductive coercion. Again, I'm not aware of any appellate case law on this because it's such a new statute, but basically that means that if in the course of a conversation, one of the spouse says, you should get pregnant, or tampers with birth control, or there's even just a suggestive comment in relation to reproduction, then there might be a basis for a restraining order. So, as you can see, the acts of abuse that you can get a restraining order, a domestic violence restraining order in California, are extremely broad and actually extremely specific. So, a lot of the language related to coercive control, a lot of the language related to what constitutes disturbing someone's peace is extremely vague and broad. And so, even if you think that you may not be a victim of, quote, domestic violence in California, you may well have a legitimate legal basis to filing a restraining order. Alternatively, if you think, on the other side, that you've never engaged in domestic violence with respect to your spouse or boyfriend or girlfriend, you actually may have, and you may reasonably worry that your spouse could legitimately file a restraining order based on these notions of coercive control and or disturbing someone's peace. And again, there are extreme and important outcomes for getting a restraining order. They can have effects on custody. They can have effects on your job. They can have effects on immigration status. So they certainly should be something that you're going to be taking very seriously. Guys, if you have any other questions about domestic violence restraining orders in California, definitely let me know. Visit me at vjlaw.com. Take care and all the best.